Hello everyone, my name is Olga Cronin and I'm the Surveillance and Human Rights Policy Officer at the Irish Council for Civil Liberties in Ireland, and also the International Network for Civil Liberties Organisations, otherwise known as INCLO. I'm hosting this RightsCon session on behalf of INCLO. INCLO is a network of 15 independent national human rights organisations from different countries: the US, Russia, Israel, Canada, Argentina, Colombia, Egypt, India, Hungary, Australia, Ireland, Kenya, Indonesia, South Africa, and the UK. INCLO's members are multi-issue, multi-constituency, and independent of our governments. We advocate on behalf of all persons in our respective countries through a mix of litigation, legislative campaigning, public education, and grassroots advocacy. Today, we're hearing from 5 experts in the US, Israel, Argentina, Hungary, and India about surveillance tools and methods that have been deployed by the country's respective authorities in response to COVID-19. We've all seen how the COVID-19 pandemic has been used by governments across the globe to justify the ushering in of new laws and new technologies with sweeping surveillance and data gathering capabilities. And we believe that these technologies have the potential to put our fundamental rights at grave risk. INCLO believes that governments must proceed with caution and that ineffective surveillance methods must not be ruled out in response to an emergency, when it's possible that they may outlast the emergency and be used to further normalise surveillance. In response to the pandemic and the deployment of these tools, INCLO's members drew together case studies which outline the different surveillance tools rolled out in each respective member country, the impacts that these were having and indeed are having on people's rights, and our members' response to the same. Just to say, these tools included contact tracing apps, AI-equipped police drones, temperature screening, immunity passports, social media intelligence, thermal cameras, and moves such as the suspension of data protection rights. Based on these case studies, we collectively designed and published a set of COVID-19 surveillance technology principles that we believe governments must adhere to, and we have created these based on the shared experience of our members. We launched these case studies and this set of principles earlier this month, and they can be found at covid19.inclo.net. So today, we're welcome everyone here today, but we'll delve into 5 of these case studies and principles from the US, Israel, Argentina, Hungary, and India. And without further delay, I'd like to invite our first speaker, Surveillance and Cybersecurity Counsel at the American Civil Liberties, Jennifer Granick.
Thank you, Olga, and hello, and thanks to everybody who's attending our session. So I'm going to talk today about technology and the type of technologies that have been proposed to address the pandemic. I think one of the most marked things that I noticed immediately was that there is a great faith among the public and also among technologists that the tools that we have can be used and repurposed to solve kind of almost any problem. It's a bit of the, if we could put it on the man on the moon, why can't we blank? And I think there is a real belief that, for example, our tools that we use, like our cell phones, gather so much information about us that surely that information can be useful for this purpose as well. You can't, if your problem is a nail, then you may need a hammer, and, a screwdriver or a cell phone is not going to fix that problem. So there is, I think, an important, healthy skepticism about what technology can and cannot do in this context. That's kind of a precursor question. And then the questions are, what are the risks of this technology and what are the benefits of the technology? But very often we start out with a question of does this idea even work? And that kind of fatalism, A, that technology will work, or B, that technological tools are definitely going to be adopted is not true. We don't need to proceed from those assumptions. So every morning when I drop my daughter off at camp, the coach for her soccer team comes up to the car and aims one of those fever detection guns at her head to see if she has a fever or not. And then the coach has a little clipboard, a checklist, and sort of checks off, yes, I checked this person, and my daughter is admitted to be allowed to go to the camp that day. And this seems pretty innocuous, and in most ways it is. But the proposals that we're seeing in the United States for fever detection are not so innocuous, where you just have like a kid and a check mark on a clipboard. The proposals that we've seen have been for things like putting fever detection tools at transit stops or other places of public accommodation, or even on drones, where you can imagine some remote surveillance of people's temperature. And, possibly also that platform opens itself up to detection of other things like respiration or heart rate or those other kinds of physiological aspects of people. And, again, one of the first question you have to ask is, could these things even work? And a lot of, we've seen, some companies that have, viewed COVID as an opportunity to market their products and also to try to, make more palatable some creepy data collection practices that they already have, like internet connected thermometers that collect a history of people's physiological symptoms. But most of these tools, particularly for remote detection, are not super accurate. They have margins of error, and most people have fevers for a variety of different reasons, some of which have nothing to do with COVID-19. And many people who have COVID-19 are asymptomatic for some period of time prior to actually showing any kinds of symptoms, such as a fever. So to use a tool like this, between the technological imprecision, the fact that a fever is not diagnostic, and the fact that people don't manifest fevers even when they are contagious, means that you're going to have, for any tool like this, a ton of false positives and a ton of false negatives. And those false positives and false negatives are not costless. They come with a price. A false positive, particularly in the United States, where testing is hard to come by and where it can take days and days to get test results back, means quarantine, away from your family and your job and your responsibilities. And quarantine can be extremely expensive for people who don't have a lot of resources to make up for the fact that they can't work or that they can't take care of their kids. And these quarantines, if they're unnecessary, are expensive. On the other side, false negatives are expensive too, because you have people who have fake confidence that they're okay and can be then more inclined to engage in behavior that is risky, that they wouldn't engage in if they didn't have some sign or some sense that, actually I'm fine. There's nothing. I'm not a carrier at this point in time. The problem with the complexity of the results also can lead to, or is ripe for discrimination. Racial discrimination or economic discrimination, because anytime you have some variables where the tool is uncertain and you're not sure, then the person who's administering the test can kind of backfill and fill in their perception. So, a person with a small fever who they feel confident about gets to get into the train, and a person with a small fever who they don't like, doesn't, or feel uncomfortable with, doesn't get into the train. That imprecision is a real societal problem as well. The next problem we ask ourselves about is, are we creating a surveillance infrastructure? When the coach points the temperature gun at my kid's head and puts a check mark on the checkboard, all of that can just be thrown away at the end of the day. But if you build installations where you have physiological monitoring at various checkpoints, or a drone that you've paid a ton of money for flying around with a bunch of equipment on it, then you get into that situation where once you build it, they will come, and you have an infrastructure that can be abused and misused for many other purposes. And so, we look to, is there a public health need Do people have knowledge, and have they given consent for their monitoring? Is their data collected and preserved? There's no need for data to be collected. As you can see from my camp example, the data is not stored, and then that there's no punishment. People will not feel comfortable if they think that having a fever means that they're going to be reported or taken into custody or otherwise, basically come to the attention of government officials or fired from their job, or, not permitted to go to classes. What that'll incentivize people to do is to just take Advil or some other fever suppressant and not really, or not submit, to sneak around. And that's not beneficial. If it works, it's not beneficial for anybody. And that is the question: does it work? What are the public health benefits? Are public health professionals calling for this sort of thing? And is this tool going to be something that actually will work? We've seen this also, just briefly, in the context of technology-assisted contact tracing or exposure warnings, where we started out with a huge faith that the location data that our cell phones generate can somehow help find out who may have been infected by a person testing positive for the virus in the past. And I think over time, people have moved from this is definitely going to happen to a situation where it seems like public health professionals are not calling for technology-assisted contact tracing, and the kind of state of sort of medical attention has been on building out manual traditional contact tracing and protecting data that's generated from that, instead of trying to create a new tool or repurpose information we have for something for which it was not designed and is not adapted to. So that's where we're at in the United States and with fever detection.
That's great, Jennifer. Thank you so much. Just to say that the case that Jennifer just spoke about, the temperature screening, in terms of INCLO's case studies and principles, the American case study of temperature testing or checking, that underlies our first principle of efficacy. So basically, we are saying for that principle that evidence must be established to show that any COVID-19 surveillance tech will be effective before it's deployed. But thanks a million, Jennifer. Our next speaker is Chief Legal Counsel for the Association for Civil Rights in Israel, Dan Yakir. Dan.
Hello from Tel Aviv. We are dealing with a vast surveillance program of the General Security Service, which was employed to track down contacts with positive, those who were found positive as bearing the COVID-19 virus. At the beginning of March, the government, we have an elaborate act that defines the roles and authority of the General Security Service, GSS, that was enacted in 2002. And it says that the GSS is in charge of protecting the state security, the democratic regime and its institutions from terrorism, sabotage, subversion, espionage, and revealing state secrets. And for that purpose, it has vast authorities. And one of them is access to big data. The GSS has constant access to all the data of anyone staying in Israel, like citizens, permanent residents, tourists, from the mobile phone companies. Unlike the police, who needs a court order to get any information from the mobile phone companies, the GSS has constant access without the need to of a court order to all the information that the mobile phone companies have, and it is supplemented by access to credit card companies' data, data collected from cameras in public spaces, like the streets, which are filled with the cameras, shopping malls, entrances to offices, etc. And this should be used only to the role of the GSS as protecting state security. In a debatable section in the law, the government can impose another role on the GSS, but it has to be connected to to national security. And at the beginning of March, the government decided to ask the GSS to recruit the GSS to identify close contacts of people who were in close vicinity to positive COVID-19 persons. And for that authorization, it needs, for imposing such a role, a new role on the GSS, it has to get authorization of a subcommittee of our parliament, the subcommittee that oversight the secret services. But it was immediately after our last election, and the parliament was inactive, so they couldn't get that authorization. So they opt for doing that through emergency regulations. In a state of emergency, which the state of Israel is since its inception, since it was established in 1948, the government has an authority to issue emergency regulations for 3 months that can surpass any law. We, ACRI, the Association of Civil Rights in Israel, filed a legal challenge against those emergency regulations using the GSS, arguing that this is illegal because it has nothing to do with the state security, and the government could not have involved the GSS in such a role. The court held a hearing. It was troubled by the fact that the parliament did not have any say in that decision, and because the parliament started being active, the government opted to its original plan to ask the subcommittee for an authorization under the GSS Act. For the first time in the history of this subcommittee, the subcommittee on the secret services held a hearing not behind closed doors, and we and other NGOs had a chance for the first time to participate in the hearing, to testify before the subcommittee, and to oppose the resolution of the government. But the subcommittee did authorize, did approve this resolution. We amended the petition and got back to our Supreme Court and asked to annul this resolution for some historical reasons I won't get into. Our Supreme Court, which is the highest court of the land, is the first and last instance for most of the constitutional petitions we file, so we go directly to the Supreme Court. So we amended the petition challenging the resolution of the government that was approved by the subcommittee of the parliament. The court held a hearing, and an important decision partially accepted our petition. We have argued that the GSS cannot be used to any civil cause like protecting the health of the population, because even if the government has an authority to a wider scope to impose on the GSS wider roles then specifically enumerated in the Act, it must be, it says, the law says that it must be connected to state security and protecting health. It cannot be defined as state security. The court didn't agree with us. It says that state security is much larger than security against terrorism, sabotage, and espionage. But it did say that this special authority of the government imposing a new role on the GSS can be used only when there is an imminent and present danger. And this, the court says, was the situation at the beginning during the first wave of the COVID-19 pandemic. But if the government wants to continue to use the GSS any longer, it must introduce the legislation to the Knesset and go through the full process of legislation, which is 3 hearings and a full hearing before a committee of the parliament. After the decision, the first wave of the COVID-19 pandemic dwindled in Israel, and the government decided not to go ahead and introduce such legislation. We thought this threat is over, but now we are in the midst of the second wave. There are about 1,800 positive cases a day out of a population in Israel of 9 million. Before, during the first wave, we had maybe 100 positive daily positives. So the government decided to go ahead. It passed an interim, a temporary law for 3 weeks that allowed the GSS to continue to identify close contacts of positive COVID-19 persons. And it was revealed that this tool that has some mythical aura around it is not very accurate for the task. Around 60,000 persons were sent to isolation because they were identified by the GSS as those who have been in close contacts with positive COVID-19 virus persons, but during their appeals, more than 50% of them were released from isolation because it turned out that this tool is not very accurate for the task. It has troubles identifying people in buildings. If it was a neighbor behind the wall, this tool of the GSS would identify him or her as well. And there was a big uproar of public opinion against the use of the GSS. We filed a second petition against the temporary law. Now the parliament amended the law and extended it to March 2021. And next week we will file the third petition against the current law. And our argument is that the law is unconstitutional. It's infringed upon the right to privacy. It's not accurate. There is a voluntary app that the Ministry of Health introduced yesterday, which is much more accurate because it uses Bluetooth technology, and the GSS should not be involved in such a task. The state attorney's office couldn't bring even one example of a democratic regime that used the secret services in the fight against the COVID-19 virus, and Israel should not be the precedent to that. It's a much harder case. It's not a government resolution, but it's a primary legislation of our parliament, we will see in the coming weeks or months if our Supreme Court will be able to live up to the challenge and to overturn this piece of legislation.
Thank you very much, Dan, and the very best of luck next week when you return to court. It struck me when you said that 60,000 people were sent to isolation, but on appeal, 50% of those people were released because of false positives, basically, which harks back to I think Jennifer's point about false positives and false negatives with temperature testing. That's really interesting, and the best of luck next week. Thanks, Dan. And just to go back to the principles, the Israeli case study was the basis for our principle of primary legislation. So we say that COVID-19 surveillance tech must be backed by primary legislation with sufficient levels of detail to allow democratic scrutiny and debate and to ensure meaningful safeguards such as sunset clauses and purpose limitation are established in law. So our third speaker is litigation and legal defense lawyer from the Centro for Legal and Social Studies in Argentina, Margarita Trovato. All yours, Margarita.
Hi, thank you, Olga. Hi, everyone. Thank you. As Olga said, my name is Margarita Trovato. I'm a lawyer at CELS, Argentina. And as it usually happens to me when I take part in these kind of conversations, we are very many steps behind in Argentina from what everybody else comments on. So I'm going to talk about a bit of the context here. We've been in strict lockdown since March due to COVID, of course. And when it began, the National Security Ministry announced that it was going to do what they called cyber patrolling, meaning to monitor everybody's social media in order to measure the social mood and to ensure the compliance of lockdown as to avoid what they call riots or demonstrations that could put at risk the public order. This increase in social media surveillance that they announced presented a couple of problems. First of all, it refers to open source intelligence that it's not even regulated here. I mean, we do have an intelligence law and a data protection law, but they are both very old and insufficient, and they don't even mention what OSINT or open sources are. Of course, from international standards and from the rest of our norms, we can deduce that mass surveillance cannot be allowed, but there's nothing specific referring to what OSINT can be understood as. Moreover, historically here in Argentina, the intelligence agency and other ministries, when it comes to security issues, work in complete secret. They don't give any public information on what they are doing or how they do it, under which parameters, who controls it, etc. And usually justify it by saying that it involves national security or state security, similar to what Dan from Israel was mentioning. And therefore, it would be a risk to share it. So there's a lack of legal framework, but there's also a lack of oversight mechanisms, or at least of properly working oversight mechanisms. There's a parliamentary commission that's in charge of controlling intelligence activities from the federal agency and from other agencies, but it has almost never said a word on this and usually agrees with the secret. Actually, the commission itself worked in complete secrecy. And the judiciary has been ruling in similar terms, never in favor of the publicity of this kind of information. So the civil society control has also been quite restricted. We've tried to access to information regarding these kind of practices, and we've never had a clue on it. So what activities are being rolled out and which technology is being deployed are usually both kept under secret. We don't even know what information the government has of us. So you can imagine how concerned or worried we were when at the beginning of the lockdown, the security ministry announced that the surveillance would be increased. When we heard of it, we at CELS submitted this request for public information, just to know a bit what they were referring to, what they understood as open sources, what they were planning to do, what they were going to increase in comparison to what they had been doing previously. This request went unanswered. We're still waiting for the answer after 2 or 3 months, I would say. But a few days later, after we submitted it, the ministry started a process of consultation with different civil society actors, including CELS and other NGOs we usually work with, and presented us a draft of a protocol to regulate this activity. We submitted some comments and a series of meetings took place until a final protocol was released in, I think, the 1st or 2nd of June. It does include some of our suggestions, and it's supposed to last only while the health emergency declared after the pandemic lasts, meaning this should not be valid anymore in March 2021. But it still has major problems, I would say. First of all, it still allows illegal intelligence gathering because it allows mass surveillance, since it does not define properly in which cases it can be done. For example, it provides a list of crimes for which, when surveillance can be used to prevent, and some of these crimes are not even related to the pandemic, while this was supposed to be a tool to ensure the lockdown. So again, it allows mass surveillance with no specific reason, and it does not provide a regulation, again, or a definition for open sources. What it does establish, that I think it's good to mention, is a dialogue between different government agencies, including the Security Ministry, and civil society representatives, including CELS and our allies, that has the function to monitor a bit the process, how this goes on. It has only reunited once since the beginning of June, but there the authorities said something informally, but I think it's worth mentioning it, that it's that no software has been bought for this practice, and apparently no software is being used. So I don't know, this makes us think maybe it's done manually. That's what I say. We are actually many steps behind. I was listening to what Jennifer said of technologies deployed in the US. Here, apparently, we don't even have software for mass surveillance. But I think it's important to mention that as we have no idea of what goes on, we learned on the occasion of the G20 summit that took place here in Argentina a couple of years ago, I think it was the end of 2018, that our defense ministry had bought a software from an Israeli company named Rafael Systems, that you might have heard about, that does mass surveillance using artificial intelligence and machine learning from open sources. The only thing that was officially published by the government was the purchase of this software, but nothing about how it was going to be used, the function it had. I mean, this I just said, we learned it from the press. We don't know under which parameters it works, who runs it, who controls it. It did not pass through the Congress. So we know, for example, that the government, the federal government, has this software. Apparently, it's not being used now in the context of the pandemic, but we have no idea of what it's used for, when, even if it's in use, maybe, I don't know. So this is the scenario of our, I would say, inexistent maybe, or poor legal framework and the oversight mechanisms. But while we were discussing all of this in the last 2 months, I think now, cases were already occurring. Cases were already being filed against people thanks to this cyber patrolling practice. I would like to mention specifically the case of a 20-year-old man named Kevin Guerra that we are now representing from CELS. This is a very particular case. I think it's a bit incredible, unbelievable. He copied the text of a meme that contained the word looting and published a sarcastic tweet after learning that he wouldn't receive the state's national emergency aid that was given to everyone in the context of the pandemic. In his tweet, he joked, and I quote, "Hey, what's up? Those of us who don't collect the 10,000 peso bonus, the looting still stands, right?" 2 days later, he was informed that a criminal investigation was being conducted into his tweet for public intimidation. I don't know if the translation works properly, but in Spanish, it's very easy to understand. It's an irony, it's a joke, it's not calling for public disorder or anything, but still the criminal investigation is being conducted, the charges were pressed, and now we are defending him from CELS, arguing, of course, that the case has to be dismissed because what they have done goes beyond the legal powers of Argentina security forces and, of course, is contrary to freedom of expression and the right to privacy. And moreover, there are, I think, 7 or 8 cases now similar of the one of Kevin Guerra that we've heard of course, through the news because there's no official information being conducted into them because of tweets sharing fake news or these kind of jokes that are understood as a real threat to, I don't know, order. So to sum up, what I wanted to point out is that our main problem here isn't only, at least, the surveillance tools themselves that are not even as sophisticated as in other countries, but our main concern has to do with the scenario in which these tools are deployed. The lack of framework, the lack of oversight, the total secrecy. We don't even know where we're standing. So that's it. Thank you.
A million, Margarita. That was brilliant. Very difficult sphere to work in when you don't know like that. Just to say, in the case of Kevin's case that you mentioned there, where a criminal investigation was launched into him after a sarcastic tweet, that case was the basis for our principle of expression. So we say that the right to expression and opinion does not impede the fight against Covid-19, and Covid-19 surveillance tech must not be used to target those who speak out or who are critical of those in power. But as you have said again, that he was being sarcastic. So our next speaker is a legal officer at the Hungarian Civil Liberties Union, Ádám Remport. All yours, Ádám.
Thank you for the introduction, Olga, and hello to all. I would like to talk to you about how the Hungarian government, under the pretext of or in connection with the coronavirus outbreak, essentially suspended all data protection rights if the data protection right had to do anything with the pandemic. So the Hungarian government introduced a state of emergency in May, which allowed it to rule by decree. And these decrees can suspend fundamental rights as long as they respect their essence. And now it is not exactly clear whether they can do this with a European Union regulation because the data rights in Hungary are granted by the General Data Protection Regulation of the European Union, but the government did this anyway. So in essence, they issued a decree which said that no data rights such as being informed whether your data are being processed by a data processor or gaining access to your data or having them deleted or restricted could be exercised as long as the state of emergency endures. So obviously the ACLU thought that this was a very broad interpretation of how data protection rights can be suspended. And along with two other NGOs, we wrote an open letter to the European Data Protection Board, the EDPB, in which we asked it to issue an infringement procedure against Hungary for breaching fundamental European Union rights. As a result of our open letter, the EDPB, the European Data Protection Board, issued a statement in which it actually agreed with most of our points. It has agreed that restrictions of fundamental rights cannot be as general and extensive and intrusive that they void fundamental rights of its basic content, because this cannot be justified. It also underlined that even though under the General Data Protection Regulation, governments have the right to restrict fundamental rights, they still have to respect their essence. So basically, there has to be at least some kind of reasonable connection between the restriction, the strictness of the restriction, and the goal that they want to achieve which was not the case in Hungary. So furthermore, the EDPB agreed that the Hungarian legislation did not exactly meet the criterion of being prescribed by law, because restrictions must be foreseeable. It's important to mention here that the Hungarian government issued the state of emergency for an indefinite period of time, for which it had been widely criticized in Europe and, as far as I know, all over the world. So logically, this also meant that the data protection rights could also not be practiced for an indefinite period of time, which was in breach of European Union law. They also stressed that the mere existence of a pandemic or another emergency situation cannot be the basis of the suspension of rights for an unlimited period or without or with an unlimited scope, and that the restriction must clearly contribute to the safeguarding of an important objective, which was not exactly the case, because the government never really told why it was necessary to suspend these rights in such a broad scope. It was never communicated why it wouldn't have been possible to make legislation that was less restrictive. And actually, the EDPB found that this was so, that this was a legitimate claim on our behalf. Yes, as a matter of fact, the EDPB also pledged or also decided that it was necessary to examine Article 23 of the GDPR more. This is the article that allows national parliaments to derogate from the general data protection regulation, because it was not clear how much they can restrict fundamental rights during an emergency situation. And basically, I think that this was also one of the main goals why we initiated this statement, or why we asked them to issue a statement. It was because Europe as a whole had never before been confronted with such a situation. And actually, a state of emergency had never been introduced in Hungary before. So it was not exactly clear how to restrict fundamental rights in such an extreme situation, especially when a state of emergency is also formally declared. And I believe that the European Data Protection Board gave us some really important guidelines guidelines that should be taken into account when restricting fundamental rights. So I think that basically this was it. This is the essence of the situation in Hungary. So thank you for your attention.
Thanks a million, Ádám. I really appreciate that. It's a fascinating case study, just to suspend the laws like that. So I really appreciate you sharing it with us today. Just to say, the Hungarian case study was the basis for our principle of data protection. We say that the personal data protection must be upheld in all emergency measures, and that data protection guarantees for COVID-19 surveillance tech must include a rights framework, personal data processor obligations, and a data protection regulator or something similar. So our last, but by no means least, speaker is Siddharth from the Human Rights Law Network in Delhi in India. We've already said this earlier off air, but just to say a big thanks to Siddharth, because he's joining us very late from Delhi, so we really appreciate him being with us here today. Thanks, Siddharth.
Thank you, Olga. Hi, everybody. I hope everybody's healthy and safe. I want to talk about the Arogya Setu, which is the contact tracing app which was introduced by the government of India fairly soon after we started taking the COVID-19 situation seriously. Around the middle of March is when our government declared it to be a health emergency, and within 2 weeks, by the 2nd of April, the government had launched Arogya Setu. Many countries have since or had already introduced such contact tracing apps in their countries. But the major difference was that other countries' contact tracing apps used only the Bluetooth function of your phone. So you were only alerted if you came close to somebody who was COVID positive or who went on to get tested positive for COVID. The major difference with Arogya Setu was that it was using your Bluetooth services as well as your GPS location services, and it was recording your location every 15 minutes. Even though that didn't really serve any purpose of letting you know that you came near somebody who had COVID. But it was constantly collecting your your location data, sorry. Another difference was that in every other country, the only thing which was recorded was your Bluetooth and your identity of the phone. But in Arogya Setu, you had to give your name, you had to give your sex, your phone number, your profession, and any of the countries which you might have traveled to in the last 30 days. This was obviously only when flights were still allowed. So it was collecting all this personal information, which again had no bearing or had no relevance to the purpose of the app. And the biggest difference between Arogya Setu and every other app in the world was that every other country said that this is an app which is going to be completely voluntary. People are free to use it or not use it. Arogya Setu started off being a voluntary app, but very soon, within a month, the government announced that all employees, be it in the government departments or in private companies, would have to download the app. And if they failed to do it, they would be prosecuted against the Indian Penal Code, and they could face up to 6 months of imprisonment. So that was the biggest, most dangerous challenge posed by Arogya Setu, where the government could make it compulsory for you to disclose all this information, and for you to make available your location information, and for allowing it to be recorded. Fortunately, we didn't actually come across any cases where people were prosecuted for not downloading the app, but there were people who were being granted bail by the criminal courts only and only if they downloaded the app. That basically meant that if you refused to download the app, you would stay in prison. This was an extremely pernicious thing to happen. Another very major problem that happened with making this app non-voluntary was that they made it mandatory for you to download the app if you wanted to travel by air or by train. And this was particularly very, very problematic because soon after the lockdown was imposed, millions of migrant workers who belonged to the villages or to the countryside had moved to the larger cities in the country to work, started moving back to their villages because they didn't know how long they would be out of job because of the lockdown, and they wanted to go back to their villages. And because trains and buses had been shut down, everybody was walking. And because of that, more than 100 people died on the road while trying to walk back home. And by making the app mandatory for you to use rail travel, even when it became permissible, was that only about 30-35% of Indians have smartphones. That meant that even when the lockdown was partially lifted and people were allowed to take the train back home, many people would be precluded from doing that simply because they did not have a smartphone. So this was the major difficulty with the app being a mandatory app. The next thing was that nobody was really taking responsibility of the data collected by the app. There was no limitation on which government department would be even allowed to use the data collected. And there was no information or no clarity in the terms and conditions of the app or any statement of the government saying that this department will be responsible in case there is a breach of data. The terms and conditions actually expressly said that the government will not be responsible in case there's a breach of the data. And this is when there was a very prolonged demand by activists that the source code be made open so that activists could study the buildup of the app and have flag the problems in the app. After very long, they actually released the source code, And in about a week's time, activists realized that this is not the actual source code used by the app, by the current version of the app. So this was, again, first they don't disclose the source code. Once they do it, they actually deceive people by putting out the wrong source code for the app. All of this was happening. India, as many of you might know, does not have a data protection law in place right now. Be that as it may, there is a judgment of the Supreme Court, a 2017 judgment called the Puttaswamy judgment, which laid down some guidelines for the government measures which could have data or privacy implications. And there are 3 or 4, 5 criteria. The first one being that there has to be legislative backing for the government measure, which was completely absent in the present case. The next requirement is that it should be proportionate. And proportionate meaning that there is, first of all, that this measure is going to be efficacious in achieving your goal. And second, that there should not be any less intrusive method available. And so this brought us to the question of whether the app was useful at all in its purpose. And as Dan also said, the problem with these apps could be that if it's using my Bluetooth, my neighbor could be tested positive and our Bluetooths might match. And it might say that you've come in contact with a COVID patient, which might be completely false because you've never even come across your neighbor. Or you could be traveling in a car, you stop at a traffic signal, there's a person in the next car who might be in close, who could be really close to you, like 2 meters away, but he may be positive and it will show you that you have come in contact with a person who's positive. And over time, and this research is coming out from all over the world, that this, because of the false positives and false negatives, people are going to stop taking it seriously. When they know that, no, I haven't even gone out, or I was only in the car, there's no way for me to have come in contact, people are simply going to start ignoring it, and they're going to start ignoring any alerts that the app might actually give them. So even if there was any possible benefits of having such an app, are completely done away with because of such problems. And the law, although, like I said, the law says that this is the requirement for any government measure which has privacy implications to be constitutional, there are also rules which were drafted by the government of India itself specifically for data collection during a health crisis. And the 2011 rules also said that if the data is to be collected, for health data is to be collected, it has to be done with the consent of the user. The Puttaswamy judgment also specifically dealt with endemics and said that if health data has to be collected for the public health purpose, it has to be anonymized. So, but unfortunately with the Arogya Setu, your name, age, sex, profession, all of this was being collected. Your data, your location was being recorded every 15 minutes. And you don't know who all is going to be using this data. You don't know who to go to in case there is a breach of data. You don't know who to go to if you want to, even if you delete the app from your phone, your account still exists. So you don't know whether my data could be erased when I want to, or even when the pandemic is eventually over. You don't know whether that data is going to be deleted or whether it will stop tracking your location. So all of this culminated in a writ petition that the Human Rights Law Network filed in one of the state high courts, in the Karnataka High Court. And we challenged the constitutional validity on all the grounds that I just discussed. That is still pending because even most constitutional matters in India take a bit of time to see the way through. But initially on in the hearings, the government of India made a very significant change in their position and said that for air and rail travel, downloading the app will not be mandatory. So that was a big achievement early on in the litigation phase, but the existence of the app itself is still in challenge, and we are waiting for the Karnataka High Court to finally deliver a judgment in that case. That's it. Thanks.
That's great, Siddharth. Thanks a million, and the very best of luck with your case. Dan, I just noticed there that there's a question for you. It's just saying, what about the government cooperation with NSO Group to track the virus? Can you speak to that?
The Ministry of Health approached a few private companies. I believe that NSO was one of them, to ask whether they have an adequate technology. And initially, they wanted to use private companies instead of the GSS for surveillance. But in their response to the Supreme Court, that said that first the technology of the the technology of the private companies was not accurate enough or elaborate enough as the one that the GSS has. And secondly, that the companies refuse to sell the software to the government, and that meant that if the government would have used one of the private companies, they would have had to give them all the big data on all the citizens, and that's a much greater infringement than using the data that the GSS has anyway. So finally, it wasn't being used. A private company was not used for that purpose. As I said before, the Ministry of Health issued a voluntary app yesterday, but they don't do much they don't do a campaign to spread it out, and it's not clear how many citizens would opt to download this app.
Thank you, Dan. I suppose we have just a couple of more minutes, but I suppose just to say from my perspective, I'm here in Ireland, and ICCL has been engaging with the government and the health authorities here on our own contact tracing app. So our app is based on the Google and Apple API, which more and more countries in Europe are using. And I think there's maybe 4 states in the US who have said they might, but I don't think it's happened yet. And just to flag for our people who are watching, ICCL has been very, very lucky the last couple of months to work with 2 brilliant computer scientists at Trinity College in Dublin. And they've done Trojan work on contact tracing apps in general, Bluetooth technology, but also they seem to have done the first examination of the Google Apple exposure notification service. So they've taken a look at that and to check out basically how private it is or its privacy. And they found a very interesting result, which is that for Android users of these Google Apple API based contact tracing apps, they have to use Google Play services. And it would seem that Google Play services in and of itself, regardless of the app or not, but just bear in mind that for the Google Apple API based apps to work, they must have Google Play services on. But there seems to be significant data gathering from that API, or from Google Play services rather. And it's a very interesting study. I hopefully maybe one of my colleagues will put it in the chat group on the RightsCon website, but and Inclo will tweet it later. But it's a very interesting read for people who are looking at the Google Apple API based apps. Okay, so I suppose it's time to say goodbye, but I just wanted to say thanks a million. A big thanks to everyone who came here today and took part, but also everyone who watched our session. And I'd also like to say a very big thank you to the staff at RightsCon for being so accommodating and helpful in organising this today. They've taken on a mammoth task, and I completely appreciate their hard work. At Inclo, we will continue to monitor how these tools develop that we've talked about today as governments continue to respond to COVID-19. As mentioned at the beginning of the session, we'll also continue to urge governments to proceed with caution. We'll take action when necessary, and we will be advocating against the use of emergency tools post-emergency in order to curb the ever-increasing normalisation of surveillance. And we would urge anyone watching to do the same. Just to remind our viewers that the case studies and principles, they can be found at covid19.inclo.net. And we also have case studies pertaining to protest rights and policing during COVID-19. So there's lots to read if you wish. So that's it. Thanks a million.